Hello, everybody, and welcome again to our free webinars with Meirc Training and Consulting. So today, our topic is about intellectual property overview. Well, let me start first by saying that this free webinar seeks to explain what the term of intellectual property means, the benefits derived from IP, and throughout this half an hour, we will learn about the different domains of intellectual property and their different type of protection. So this is the aim of our, half an hour. Having said that, let me introduce myself. My name is Charles. I'm originally from Lebanon. I have a bachelor degree of law and a master of science and human resources management and training from Leicester, UK, and many certification and years of experience. However, I will not waste your time about those. You can go to our website www.meirc.com, and you can see all of our teams, services, free webinar, article blogs, and for sure our training, virtual learning, and so on and so forth. So what to expect in this half an hour? In this webinar, you will be introduced to intellectual property, the type of intellectual creation covered by the intellectual properties, so namely copyrights, related rights, and trademarks. So throughout some questions that we will ask you, we will ask those questions, and basically when we reply, we will be, explaining about, intellectual property. So what is intellectual property? So before I start about intellectual property, it is very important for you to know that intellectual property and the protection of intellectual property is critical for innovation, and this is the main idea about IP. So without this protection, businesses, individual will not benefit from their innovation and will not focus on research, development, and creating new things. And this is why the history of humans is a history of application of imagination, innovation, creativity, and it's been this imagination and this creation that enable us as humans to advance to the levels of technological progress that we reach now. So protecting that intellectual property is ensured not only at the national level, but at the international level as well. Basically this webinar is based on the reference is the WIPO. What is WIPO? It is the word intellectual property organization. So bear with me, I will still ask some question, and I will give you today in this webinar 4 small quizzes, and I will see who is really learning from this webinar. So let's continue. So again, what types of intellectual creation is under IP, intellectual property? It is generally understood that there are many rights under IP, namely, so what are those 8 sections, if I want to say? So first, literary, artistic, scientific works, those are under copyright. The performance, so when I have for instance, I wrote a book, this is copyright. But however, if somebody wants to perform, an artist, he took the permission, he want to perform, on theaters, operas, phonograms, broadcasts, this is called related rights. You have also all the innovations are under something called industrial property rights, scientific discoveries, industrial designs, commercial names, those are industrial property, and then protection against unfair competition, all of these are industrial property, and all other rights resulting from intellectual activity in the industrial, scientific, and artistic fields. So it is a wide subject, intellectual property, and you have many windows. Let's start with the most known and obvious window, which is the copyright. So what is copyright? So copyright aims at providing protection to the author. So who has created? Basically, it's writers, artists, music composers, etc., etc., etc. So on their creation, so the work that they provide, this should be protected. Why it should be protected? Because it is something original, it is something new. So having said that, what is covered? So I know it's the work, it's the artistic work, it's the composer, the writer. So let's go into details. So work covered by the copyright include, but not limited to, the following. So literary works such as novel, poems, and plays. So everything it's written, it's something novel, something new. Poems, plays is under copyright. Reference works such as encyclopedias, dictionaries, database, newspaper articles, film, TV programs, musical composition, choreography, artistic work, painting, drawing, sculpture, architecture, advertisement, and maps and technical drawings. All of these are under the protection of the intellectual property, and namely under the window of copyrights. So what is covered also, in addition to those, you have the copyright also protect computer programs. So copyright does not, however, extend to ideas. So here it's very important to know that when I have an idea, and it's a new idea, it's not directly protected under the copyright. Why? Because there are some legal steps I should take. So don't you ever share a new idea with person that you don't trust. And second, you have to follow some steps in order to protect your new idea. For example, the idea of taking a picture of a sunset, it's not protected by copyright. If I took a picture and I did not do the legal steps, it's not protected. Anyone can take can take and use that picture. However, but a picture of a sunset taken by a photographer, and he did all those steps, it is protected under a copyright. In such a case, if someone else make a copy of the photograph and start selling it without the consent, the approval of the photographer, the person would be violating the photographer right, and the photographer may go to a jurisdiction, so a complaint. However, so now we know that the copyright is protecting a certain type of work. My first question to you, and now I will send you the first test, test to see if you really get to know the first, pillar of our webinar, which is copyrights. So I will send you the test number 1. There is only one answer is right. So it's a multiple choice. You have one answer that will give you 10 points. I shared with you now the test. Please try to answer the following question. So the first question is, again, if I draw something, filled out the registration form, paid the required fees, and receive an official certificate of registration from the registrar's office, I am protected under which IP right? Is it trademarks, copyrights, related rights, or industrial property? So I have 57% of right answers. I'm still waiting for 2 to give me their answers. Okay. Still, I'm 57%. So, yep. I'll be ending the vote. I will end the voting soon. Still waiting for someone. I will end the voting now, and I will share with you the results. So now you know that based on the result and based on what we have explained, I am protected under the copyright because this is an artistic work that is protected under the copyright. So now I'll stop sharing. So let's continue. So it is under the copyright protection. However, we have more than the copyright under IP. But in the copyright specifically, we have two, let's say, types of rights under the copyright. You have the economic rights and you have the moral rights. So let's go to the more tangible rights, which is the economic rights. The economic rights are the rights of reproduction. So if I have something that I created, I can use it and I can reproduce it. The distribution, the public performance, the broadcasting of it, the translation into other languages, and the adaptation. All of these are economic rights. Basically, are the rights of the author of this, novel or this artistic thing. The other type of right is the moral right. So as an author, I have the authorship to recognize on the work. So I have the right to have authorship recognized on my work. So this work, it is for me under my name. So when you go to, let's say, to do a dissertation or an essay in your university, you have to mention the reference and the citation, and this is the right of the author. And the second moral right is the integrity of the work, that my work should stay as is and not to be changed and altered. And this is very important in the under the copyright and under the IP that we are covering in today's webinar. Let's continue. So if I ask myself, how long does copyright last? And this is a generic question. Copyright has a time limit. It usually lasts for the life of the author and 50 years after his death. So it is a lengthy time of protection. So when you do the protection, you are protected mainly for a lifetime and even after your death for 50 years. This rule, which is shared by most countries, has been established by a convention. It is a Berne Convention for the protection of literary and artistic works. It's good to know. However, can you use someone else's work without permission? Here there are some exceptions. The rule is, not to use without permission, but basically copyright is subject to some limitation and exceptions, which consider social, educational, and other public policy consideration. For instance, in international treaties as well as national laws, we allow to freely use some portion, small portion of a work for certain purposes, such as news reporting. So if I took a part of a work and I use it for news, for a quotation, with fair practices, illustration for teaching, so I use someone's words for teaching without his permission, it is allowed to a certain extent. So in other cases, such as cases of free use, may vary from country to another, and it is advisable to revert to the national law of that country to verify whether advantage can be taken of such possibilities. So here there are many different laws in different countries. Some countries, they allow you to use that quotation or that a small portion or a larger portion, and some countries are rigid in this specific subject. So the test number 2. So which of the following is not legal? So which of the following is not legal? I will share with you also the test. So vote on the following. So the question is, which of the following is not legal? So the use of quotes is not legal, the use of small portion for a commentary, the use of a full text in a scholarly report, or the use of a small part in news reporting. Based on what we just saw, which of the following is not legal? It is, the question is, which of the following is not legal, not which is legal, which is not legal: the use of quotes, the use of small portion, the use of full text, or the use of small parts. Till now I have 29% only of right answer, but yet I have only 2 people who answered. Still I have 29% of answers. However, basically, I want to send my greetings to all of you, namely Fuad, Kabiru, Khalid, Maya, and Taisir, and others. Thank you so much for attending, this IP session. So till now I have 86% answers, and you've got 57%, the right answer. I will end the voting for now, and I will share the results with you. Very good. So basically we have only half an hour. Because of that, we will continue and we will hit the ground running. What are the related rights? So we finished with the copyrights. So we said that the copyrights are the thing that an author presented as an artistic work or data or so on and so forth. So related rights, what are the related rights? Related rights provide protection to the following person or organization: performer. So I'm not the author of a book, but I am a performer, I am an actor, I am a musician, singer, dancer, people who perform in their performance. So the performance that I do, it is protected under IP, and it is called the related rights. So producers of sound recording, so cassette recording, compact disc. So I took, for instance, a permission from a musician and I recorded his music, and now I am a producer, or I have the recordings. So I am protected under the related rights for those recordings. Broadcasting organization. So when a TV or a whatever broadcasting organization, or a radio television program, those programs are protected under related rights. So very important subject, IP. I guess you are now thinking, yeah, it is something that we should take care of and we should know and more about. So copyright and related rights protect different people. So again, in order to focus on that specific idea, copyright protect authors of the work. For example, in the case of song, copyright protect the composer of the music and the writer of the word. However, the related right would apply to the musician and the singer who performs the song, the producer of the sound recording, also called the phonogram, in which the song is included, and the organization that broadcasts a program containing that specific song. I guess that you by now know the difference between the copyright and the related rights. So let's go to test 3 if you understood the difference between those two. And in the question number 3, or the test number 3, it is a straightforward test. It has two questions. The first question is, trademark protect the author work, right or wrong? Or if someone performed the author work, she is protected under the related right or wrong? So trademark protects the author work. It is called trademark. I don't know. If someone performs the author's work, she is protected under the related right or wrong? So till now we have 7%, 7%, 29%, which is great. 21%. Only 21% till now. I'm still waiting for 2 or 3 more answers. Still 21%. So the first question is related to the first part actually, and the second is related to the related rights. So I guess I give you some hints here. Okay, we have 21% only of right answers, which is okay. I will share the results with you. So again, let me give you the right answer here. Trademark protects the author work. No, it's not the trademark, it's copyright. And then if someone performs the author's work, he is protected under the related right. Yes, it is under a related right because he's not the author of the work. He is performing the author's work. So very good. Let's continue. So let's move to the third section, which is covered under today's webinar, which is trademark. So what is a trademark? A trademark, now we will forget the authors and the performers. It's something related more to businesses. So it is a trademark is a sign that is used to identify certain goods or services as those produced or provided by a specific person or enterprise or a company or an organization. Hence, it helps to distinguish those goods and services from similar ones provided by another. So now, any product in the market, when I'm using a name, you will link it directly. You link that product to the enterprise. You link that product to the organization, and this is called a trademark. Trademark as well is protected under IP. It is very important that you protect your trademark under IP, or else they will use the same name for a different product, and here there will be a catastrophe from a business perspective. So what function does a trademark perform? So again, we are asking a question, providing you with the answer, and namely we are and mainly we are learning from the answers. Trademarks may perform different functions. So they help consumer identify, distinguish a product or a service, enable company to differentiate between their product and other product. They are a very good marketing tool. Sometimes organizations are not well known, however their products are known, and basically based on the name of the product we link to the company and not the other way around sometimes. So it's very important marketing tool. Maybe license and provide a direct source of revenue. So if I have a good product and it's sellable product, and I give I give it to others in order to have benefit and royalties, yes, I can. Are a crucial component of business assets. So this is mainly the cornerstone of any business. Encourage company to invest and maintain and improve those quality product, and they may be useful for obtaining many finance. If I have a product and I go to the bank, I need finance, I need a loan, and then if that product is a sellable product, yes, they will give me that finance or that loan. So what is a trademark and how is a trademark protected? The most common and efficient way of protecting a trademark is to have it registered. So this is an ABC of any legal process under the IP. You have to register your trademark. So trademarks are territorial rights. So it is basically it starts with the national protection, not the international protection. This means that they must be registered separately in each country in which protection is desired. Note that unless the given trademark is protected in under specific country, it cannot be freely used by a third party. Again, so a trademark is protected in a specific country. If it is not protected, it can be freely used by a third party. So if you don't register your trademark, everybody can use it freely and no one can protect you anymore. So the trademark owner is giving the exclusive right to do what? So what kind of protection is provided by a trademark? The use of trademark to identify his goods or service. So that trademark, he will identify that this good belongs to me as a company, or this service is a sole service, or is a sole service provided by my company. The second is to prevent other from using a marketing the same or similar trademark for the same or similar good or service, to prevent other to take advantage from my product or to link it to their service or to themselves. And then to authorize other to use a trademark. Sometimes I can authorize that, but with a return, with a financial return. I give you some example: franchising, McDonald's, to name one of the international. He's very, they are very, known about their franchise or licensing agreement, and in returns for payment, for sure, in return for finance, for money. So the last now question will be the following. The last task will be, so what is the last task about? For sure, it's about, maybe trademarks and other. The trademark must be registered in the country which protection is desired, right or wrong? There are also two questions in that test. So the first one is the trademark must be registered in the country which protection is desired, yes or no? And the second one, the second question is, even though a trademark was not protected, it cannot be freely used by a third party. Even though a trademark was not protected or registered, it cannot be freely used. Is it right or wrong? So let me see. So I have 36 now. It's better, 36% the right answers, but I still am waiting for others to answer. I have 3 answers out of the full attendance. We reach 50% of points, which is great. Okay, so I'll be ending the vote. 3, 2, 1 now, and I will share the results with you. Okay, very good. So let me give you the answer first. The answer, yes, the trademarks must be registered in the country which protects it. As we said, trademarks are national, should be protected nationally first before international protection, which is the first question is right. However, even though the trademark was not protected or not registered, it cannot be freely used by a third party. It is wrong because it must be registered in order to be protected. And if it's not protected and registered, everyone can use it freely, and you cannot claim your trademark unless you're registered in a national or in an international way. My half an hour is about to end. I will leave now those 2 minutes to any questions, and I will be happy to answer. If no questions, I will just wish you a very nice day, hoping that you really benefited from this free webinar, this half an hour. In my opinion, it was full of information. Hoping that you enjoyed Meirc training and consulting free webinars. So for more information about any subject, please, or our offering and services, please do visit our website www.meirc.com, and you can find a lot of things that you will benefit from, in addition to our virtual learning and services, and our hopefully we will return also to our face-to-face deliveries and training. This is very important to visit our website. So Taysir, if I am an employee, create something during my working hours for the company, who owns the copyright. Basically, it is based on the contract. In many contract, when you use the company, material and the resources of the company, and with the help or with the encouragement of the company, and the copyright, it is for the company. However, if you went to your home, Taysir, and then you did not inform the company about your creation, your copyright, and you registered that copyright in on a national level, you will be the author, and you will be protected, and your work will be protected under the copyright. Thank you so much for attending Meirc Training and Consulting webinar. Till then, see you soon. Adios.
Meirc.com